addressed by Nia Isasurakurete, Jasi Chair of Player Non-Division and Chairman of the Ngleshi Alata Paramount Stool Council, under the Section 6 of the Native Administration Ordinance of 11th March 1929. Distinguished elders, members of the press, ladies and gentlemen, good morning and welcome. On behalf of the Ngleshi Alata Paramount Stool Council, I extend my gratitude to you all for honoring our invitation to this important press conference. This gathering is necessitated by recent developments and pronouncements, particularly by the Sempe stool, which risks distorting historical and judicial truth concerning ownership and title to certain lands traditionally belonging to the Ngleshi Alata stool. As leaders and custodians of our sacred traditions and heritage, it is incumbent upon us to set the record straight in accordance with law, truth. Permit me to state unequivocally that the issue of ownership of the following lands, Sabu Zobu, Kolegonu, Uwene, Choko, to Chem Lagoon, the Plaza Cinema area, Mampuri, Jongodri, and surrounding areas has been conclusively determined by a competent court of jurisdiction in Ghana. Ladies and gentlemen of the Inky fraternity, in 1963, Justice Akolache delivered a landmark ruling in the consolidated case of Ni Zhao Duane III and another versus J.A. Kwe and another, affirming these lands as the ancestral property of Ngleshi Alata, Jamestown. Though these rulings was temporarily overturned on appeal in 1970, the Supreme Court in 1990, in the case of Jamestown stool and another versus Sempe stool and another, reinstated Justice Akolache's ruling in favor of the Ngleshi Alata stool. These judgments, delivered by their lordships Francis Weegu, Amwasechi, Osei Urere, and Ekins, JJSC, remains the final word of the matter. Ladies and gentlemen, more recently, on the 15th of April, 2025, the High Court, suit number FAL/111/2015, again affirmed the ownership of these lands by the Ngleshi Alata stool, referencing the 1963 judgment as authoritative. His Lordship, Kenneth Edem Kudochi J, not only granted all relief sought by the plaintiffs, but reinforced the judicial continuity, affirming our stool's title and ownership rights. It is important to reiterate that the only areas affirmed for the Sempe stool is that ruling were Dama and Sakama. Thus, any claim by the Sempe stool or any other group over lands such as Choko, Kolegonu, Jongobri, or others is without legal merit and amounts to an affront to the authority of the Supreme Court of Ghana. Let it be known by all gathered and the general public that this matter is res judicata. legally and finally settled. And the only lawful avenue for redress by any dissatisfied party will be to seek a review at the Supreme Court. In the 1990 decision, anything short of this is mischief, an affront to the rule of law, and an insult to our judicial process. In line with our responsibility and authority under the Native Administration Ordinance of 1929, Section 6, particularly the Section 6, and in our duty to protect and preserve the lands, customs, and dignity of the Ngleshi Alata people, we are taking active steps to plot and register Exhibit D with the Lands Commission. This will ensure that the clearly delineated boundaries of Ngleshi Alata stool lands are formally recognized and enforced by all relevant agencies. Let me emphasize, as our Reverend Elder Sheikh Isikwe once said, Akbena, it is enough. Let peace prevail, but let truth stand tall. Thank you for your attention. Thank you.